Hello, 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 everybody, and welcome. Okay, I'm just getting the documents up here, you guys. We'll wait for a few people to get in here before we start. Hopefully, everybody is having a great week so far. Weekend is here. Woohoo! So, there's been some new filings in the Daybell case. Hello, Nana. It's Alicia. Hello. Teeny. Hello. And Nana. Be kind. Nice to see you. Haven't seen you in a while. Kat. Hello. Marie Burks. Hello. Amy. Hello. Courtney. Welcome, everybody. So there's new filings in the Daybell case. He has filed motions to strike the death penalty. We're going to go through it. He is claiming that he was Xually manipulated by Lori, amongst other things. Hello, Tarot Destiny. Nice to see you. Jason, hello, hello. The week has gone by so fast. Yes, it has. Sorry, Be Kind says, sorry, been lurking, health, been pets. Oh, I'm sorry, Be Kind. I hope you are feeling better soon and whatever is ailing you subsides. So he's filed this, and I was reading through it earlier, and it was like, what? Now, I do think that they may have a point on some things. Hello, Get. Nice to see you. Good evening from Sweden. Well, good evening, Get. Nice to see you. And as you guys can probably hear, I'm sounding a lot better. The quitting smoking is going good. I am slowly weaning myself off. So, Babs, veterans are family. Hello, hello on Veterans Day. Hello, Veterans Day in the US, you guys. Oh, Celeste, it's going to be a loin fire defense. I love it. Well, thank you. I'm not there yet. I am working on it, though. I've gone from smoking almost a pack a day down to, I think I'm down to 10. And I'm on this thing like years ago. They used to have this little gadget that you could click in how many smokes you had a day, and it would give you time frames that you have to wait now before you could have a cigarette, and it slowly weans you off. It worked for me in the past, so I can't find one of those machines anymore. But so I'm doing it manually in the morning when I get up. Instead of having that first cigarette, I wait, and then I started at waiting half an hour, then waiting an hour, and now I'm at 1.5 hours I have to wait, and I'm slowly weaning myself off the cigarettes. I tried cold turkey, you guys, with the gum and everything. It didn't work. As soon as I was done chewing that piece of gum, I wanted a cigarette. This seems to be working, and it's a challenge, and I love challenges. So it's like, I'm going to beat this. And there's a lot of times, like I think I'm down to 9 cigarettes now a day. And at the end of the day, when I'm ready to lay my head down and go to sleep at night, I still have 2 left in my package. So I'm really only having 7. So going from a month ago, smoking a pack a day, I'm down to 7 a day. So hopefully by Christmas, that's my goal, is that I am done. Because next week I go down, and every week I take 2 away. So I'm at 7 right now. So next week I will be at 5. And that's going to be like 2.5 hours between cigarettes, 3 hours between cigarettes. And it seems to me that is working good for me. And I've taken on the challenge. I say to myself, these smokes are not going to beat me. I'm going to beat them. So I'm doing good. It's so hard to quit. Yeah. And that is going to be brought up in here. We're going to go through the filings. But there are points in here. Now, I do believe the prosecution is going to argue that because John Pryor and them kept putting it off, putting it off, putting it off. It put Lori Vallow's case in jeopardy because of her speedy trial rights. She did not waive her right to a speedy trial, and they did not have her trial within the speedy right trial guidelines. So they were on the verge of maybe losing that case. That's the only reason they removed the death penalty in her case, and then severed them. So they didn't complain. You know what I mean? So there was many reasons why hers was removed. Now, is it going to be enough to have Chad's removed? We're going to go through the documents. We're going to go through the case law that John Pryor is bringing up. This is going to be a tough one, I think, for the judge, you guys. I really do think that it's going to be a tough one. So, thank you, Amy. Thank you. Well, I don't think they messed up her case. They just violated her speedy right trial, and that's why hers was removed. Okay, so let's get going on this, you guys. I'm going to bring it up on screen so you guys can see it. There we go. Let me get rid of this. I hate when that keeps popping up. Okay, let me go full screen here. Yeah, really. I don't think it should be removed from him, you guys. Yes, Lori has been transferred. Okay, so let's stick to this case for now, Jason, just so we can get through this. So we have the verified information. Okay, you guys know I go by verified information. So let's get through this. We can chit chat about it and comment on it. It's 11 pages. This was just filed yesterday. It went into the record this morning. So I got it this morning, went through it, and decided I might as well jump online and bring it to you guys live because I know you guys like the live shows. So, and for those who have sent the super thanks on my videos, I want to personally, I forget who they were right now, but I do see them. I did comment on your super thanks. The super thanks it's a little heart-shaped thing that you can donate under every video, even if it's not live. So I want to really, really thank you for that. It helps me keep going and helps me to bring you guys these lives. And also the ones who have sent to PayPal. Christine, Leslie, and Brittany, thank you for your PayPals. Okay, so let's get going here. So like I said, this was filed yesterday, 11:37 a.m. You can see it right here. I only seen it on the record this morning. So this is filed by John Pryor. You can see up top here, John Pryor. Whoops. Motion to strike the death penalty based on relative culpability. Comes now the defendant, Chad Daybell, and through undersigned counsel submits this motion to strike the death penalty based on relative culpability. During the trial of Mr. Daybell's co-defendant, Lori Vallow, the state consistently argued that Mrs. Vallow was the most culpable party to the alleged conspiracy that led to the deaths of Tylee Ryan, J.J. Vallow, and Tamara Daybell. As the state repeatedly argued, Ms. Vallow set the conspiracy in motion. She manipulated both Alex Cox and Chad Daybell, and she remained in charge of her plan throughout. As the state plainly put it, Lori manipulated Chad through emotional and, here it is here, control. So, and this is one of the reasons, you guys, why the prosecution did not want to have the cases severed. Okay? Because now Chad's attorneys are going to argue, because of what the prosecution said about Lori in her trial, that she was a manipulator, she was the mastermind, all these things, they are going to use it to try and have Chad Daybell's death penalty thrown out. You're going to see this all through here. TR 3859, 1 to 23. Now, when you see this throughout this, This is the transcript of Lori's case. And this is the either line, section, maybe paragraphs, whatever. They said, and Chad was not going to act without Lori saying so. Okay, so they're saying that this was said in Lori's transcript. Citations to the trial transcript for the trial of Lori Vallow will be in the following format: TR, page number, and line numbers. So page number 3868 and line 12 and 13, and page number, this is what they are referring to. Okay, and this is the line number they are referring to. You're going to see a lot of that throughout this. Is anybody else's super blurry? Here's my sister. Hello, hello. Can you guys see this, or is it blurry? Let me know in the chat, please. Don't mind me. I'm sipping on my tea here as we're going through this. Can everybody see this good? Please let me know in the chat. Okay, everybody's saying it's clear, Sandra, so maybe exit and come back in. Babs is saying it's blurry too. That's weird. Some are saying it's not. Some are saying it is. Hello, Sammy. Nice to see you. Sammy Smith. Be Kind says, I can see. Okay, here, let me try this. Is that better, you guys? Let me know if that. Vera Ray says, just got my notification. Yeah. For you guys that are not getting the notifications, like when you're on somebody's channel, you can click the little bell for notifications. But if you don't have the notifications on the YouTube app itself on, you won't get them. Okay. So you have to go into your device if you're on a phone or iPad or whatever, and into the YouTube app itself, and make sure that you have notifications selected to on. Because if in the app itself, if your notifications aren't set to on, you won't get them no matter how many times you hit that bell. Okay, is that much better, you guys? It's worse? Marie Burke says it's worse. Because I had it zoomed right in. Okay, so people, okay, there's not much I can do. This is the best I can do, you guys. So follow along. This is why I read it too. So you guys, Nana's saying it's worse too. So on some things, it's better for some people it's worse. Looks good, better for me. Yes, it's better. Some are saying much better, and some people are saying no. Nana says no, it's worse, and Marie says it's worse. So maybe it's depending on what you are on. Okay, so let's get going on this, you guys. Okay, so they were referring to part of the transcript, lines 21 to 23 and 12 to 13, where the prosecution said Chad was not going to act without Lori saying so. So in Lori's trial, they were saying that it was Lori who put this all together and made sure it was carried out. Now that's going to be used in Chad's trial to get him a lighter sentence. Okay. As such, per the state's own presentation of evidence and arguments in the trial of Lori Vallow, Mr. Daybell has lesser culpability than his co-defendant, who did not face the death penalty. Even when two co-defendants are equally culpable, it is unconstitutional and unacceptable to subject one of them to the most extreme punishment available, while the other did not face that possibility. Now, we do know they were both facing the death penalty. The only reason why they took the death penalty off the table for Lori is because they were really pushing her speedy right trial. They violated that, and they didn't want this thrown out, so they removed the death penalty. She actually thought she was going to get off. Okay, so that's why that was done. And it was because of Chad's lawyers that it kept being pushed out and pushed out and pushed out and pushed out. If you remember correctly, they were constantly filing motions and this and that. And you notice since the trials were severed, they didn't do that anymore. They did that to separate these trials. Okay, so let's get through this. Therefore, Mr. Daybell should not face more extreme punishment than the co-defendant that the state itself has alleged to be more culpable. Pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution, Idaho Constitution, Article 1, Sections 6, 7, 8, and 13, as well as the legal authorities cited below, Mr. Daybell respectfully requests that the court strike the death penalty as a sentencing option so that Mr. Daybell faces a maximum punishment in line with the co-defendant alleged to be more culpable. Factual and procedural background. SC Lady 48. Yeah, I was saying, I think the judge is going to have a hard time deciding on this. The state of Idaho charged Chad Daybell and Lori Vallow as co-defendants in connection with the deaths of Tylee Ryan, J.J. Vallow, and Tamara Douglas Daybell. On March 3rd, 2023, the court severed, Mr. Daybell. It's small on my screen, you guys, so severed Mr. Daybell and Ms. Vallow's trials. Ms. Vallow's trial began in April of 2023. Now, as you guys know, Lori's trial did start April 2023. Chad is starting April 1st, 2024. So exactly a year later. She was convicted on all counts and ultimately sentenced to life in prison. During her trial, the state argued that Ms. Vallow was the most culpable party to the alleged conspiracy in the following ways. Lori Vallow was the common thread between the murders and set the alleged conspiracy in motion. This plan was driven by Lori's desire for and use of money, power, and sex. And this plan, which she set in motion. Now, like I said, don't forget what I said here. This is on page 3830, lines 13 to 15 of the transcript from Lori's trial. And this is what I mean. Hang on a sec. Sorry, you guys. Okay. Sorry about that. I still get these coughing fits. Okay. So this is where they're saying that this is what the prosecution has said. And this was to get a conviction on Lori. And there was one common thread through these murders, Lori Vallow. She is the one person who ties this all together. This is in the transcripts. She's moving this plan forward. There is no question that Tylee Ryan, J.J. Vallow, and Tammy were murdered. Who is the common thread? Lori Vallow. Now, this is all stuff that the prosecution said. The evidence in this case points to one common thread, and that thread is Lori Vallow. She is a killer. Lori is the connection to the deaths. So they're saying without Lori, these deaths wouldn't happen, wouldn't have happened. So that was what they were pushing in Lori's trial to get a conviction. Right? So Lori Vallow manipulated Alex Cox and Chad Daybell to follow her. Lori manipulated Alex through religion. She manipulated Chad through emotional and sexual control. This is all in the transcripts. Okay. They were really pushing for a conviction to get her convicted, but their words may come back to bite them in the butt. Yeah, I know that Lori wasn't present when any of them died, I don't think. But they're saying without Lori orchestrating all this and manipulating them and masterminding the plans, that they wouldn't have happened. Now, being that they did this in her trial to get a conviction on her, it may come back and bite them in the butt for getting the death penalty for Chad. We're going to see why. And the defense raises some good points here, you guys. So I think the judge is going to remove the death penalty for Chad. That's just my opinion. Okay, she groomed Alex Cox. Lori uses, you know what, to manipulate Chad, and Chad seeks confirmation from Lori repeatedly. Chad telling Lori what she wants to hear, she reinforces him with Xually behavior. Lori Vallow led the alleged conspiracy throughout. And this is all stuff that the prosecution said in Lori's trial. Chad is not going to act without Lori saying so. So right there, they are saying that this would not have happened if Lori didn't say it needed to happen. This could very well come back and bite them. He's not going to get off. But I do believe that there is enough in here that they are bringing up that is probably going to have the DP removed. Like, they're going to eat their own words here. Lori is the conduit of information to Alex. Alex does what Lori tells him to do. Lori Vallow handed off JJ to Alex. Lori Vallow is telling Alex Cox what to do. In these messages, you never see Alex tell her what to do. She is telling him what to do. And this is what I mean, you guys. This is going to come back and bite them. And I'm guaranteeing you, John Pryor is going to be all over this. Melanie Gibb responds, okay, Captain. Why does she say, okay, Captain? Because Lori is in charge. What does Chad say? Just grab me by the storm and I will follow you to the ends of the universe. Not will you follow me, Lori. I will follow you. In sum, the consistent core of the state's case has been that Lori set a conspiracy in motion. Sorry, you guys, my phone is going crazy here. That she manipulated Chad Daybell and Alex Cox to partake in that conspiracy, and that she was in charge throughout her plan. Based on the state's presentation of evidence and arguments, Ms. Vallow was convicted on all counts. But she did not face the death penalty. Only Mr. Daybell, who the state has asserted was not going to act without Lori saying to, is facing the death penalty. Hey, Debbie Joe. Welcome. Despite the state repeatedly asserting that Lori Vallow Xually and emotionally manipulated Chad Daybell in pursuit of her aims, Mr. Daybell faces a more severe punishment than Ms. Vallow, despite the state's consistent argument that Lori groomed Alex Cox, continued to manipulate him, then handed her son off to be killed by Alex. Only Chad Daybell faces the death penalty. Despite the state's presentation of evidence that Chad will follow Lori, not the other way around, only the person alleged to be the manipulated follower is facing the possibility of death. Now, they both were. And I explained at the beginning of this why they had to take the death penalty off on Lori, because they violated her speedy right trial rights and they didn't want to lose this case against her. So they severed the case and took away the death penalty for her. Is that enough to have Chad's taken away? I don't know. Let's finish reading because they got some good arguments here. The argument. The U.S. and Idaho constitutions both prohibit cruel and unusual punishments. U.S. Constitution Amendment, what is that, 5, 6, 7, 8, Idaho Constitutions 1 and 6, under each punishment is cruel and unusual. if it is excessive in relation to either the circumstances and nature of the crime itself or the personal characteristics of the offender. So they're going to start citing cases here, cases that were cited. In Graham versus Florida, the concept of proportionality is central to the Eighth Amendment. Roper versus Simmons, recognizing that the Eighth Amendment's respect for the dignity of all persons includes a requirement that punishment be proportionate to the offense and the offender. Put differently, a sentence is constitutional only when it is proportionate both to the facts of the crime and to the offender's relative culpability. Given the uniquely harsh nature of the sentence, capital punishment must be limited to those offenders. Hello, Lady D. I got your email, by the way. I'm glad you got your package. Whose extreme culpability makes them the most deserving of execution. So in Akins versus Virginia, a crime may be one that inflicted hurt and horror on the victim. Sorry, you guys. If I've got a cough, I am going to mute. And it seems actually worse than when I was smoking because everything's coming out now. So given the uniquely harsh nature of the sentence, capital punishment must be limited to those offenders whose extreme culpability makes them the most deserving of execution. In Akins versus Virginia, a crime may be one that inflicted hurt and horror on the victim and that caused revulsion in society and the jury that represents it, but may nevertheless be one for which death is just appropriate penalty. Kennedy versus Louisiana. Thus, regardless of the morality shocking nature of the alleged offense, the death penalty may be disappropriate sentence based on the offender's relative culpability. With respect to the proportionality inquiry in co-defendant cases, evaluation of each individual's relative culpability in the same criminal case is a necessary element of constitutional death sentencing regime. So in Edmond versus Florida, holding that identical treatment of co-defendants without regard for their different levels of culpability was impermissible under the Eighth Amendment. When two co-defendants have the same level of alleged culpability, it is unconstitutionally cruel and unusual to sentence one to death while the other does not receive such sentence. And the People versus Kilner. A similarity situation, co-defendants should not be given arbitrarily or unreasonably disparate sentences. Disparate sentences. Can't talk today. And then Lazarler versus the state. When a co-defendant or co-conspirator is equal as culpable or more culpable than the defendant, the disparate treatment of the co-defendant may render the defendant's punishment disappropriate. Whoa, this is going to be a day, you guys. So because they're saying that the prosecution basically said without Lori being at the head of all this, that it wouldn't have happened. So he's less culpable than Lori is, that he shouldn't get a sentence worse than what Lori got. Numerous state courts have recognized the constitutional necessity of case-specific proportionality between co-defendants in capital cases. Smith versus Commonwealth. The trial court precluded the death penalty as a possible sentencing option for one co-defendant after a more culpable co-defendant pled and received a term of years. The Kentucky Supreme Court upheld this ruling. Two men were charged with murder of a motel manager during a robbery. The co-defendant who pulled the trigger pled to first-degree murder and was sentenced to life in prison. The other co-defendant, who fully participated in planning and executing the robbery but did not pull the trigger, went to trial and was sentenced to death. In recognizing the inherent unfairness of this outcome, the Florida Supreme Court reduced the death sentence to life in prison. So that's what I'm saying. Hello, everybody coming in, and welcome. Please smash that like button on your way in. Let's get this out there. 25 likes, 55 viewers. Come on, you guys. I put a lot of this into this for you guys. It's free to do. Pop out of chat, smash the like. When you come back into chat, make sure you've got live chat selected at the top so you don't miss anything. I'm waiting. I'm waiting to see my likes move from 25 up. Come on. Be nice. Hello, Kate Bell. Stormy, wasn't the death penalty taken off, Lori, because prosecutor? It was taken off because thank you guys for hitting that like. Thank you. Death penalty was taken off the table because they violated her speedy right, her right to a speedy trial. And because they kept putting it off. And thank you, Sammy. And because of Chad's lawyers keeping on filing these motions, which had to keep putting the trial out further and further and further, they were going to lose their case with Lori for violating her speedy right trials. That's why the death penalty was removed. So they didn't lose the case. So we pride ourselves in a system of justice that requires equality before the law. Defendants should not be treated differently upon the same or similar facts. Thank you, Amy. Defendants, when the facts are the same, the law should be the same. The imposition of the death sentence in this case is clearly not equal justice under the law. We recognize the validity of the Florida death penalty state, but it is our opinion that the imposition of the death penalty under the facts of this case would be unconstitutional under application law. Always even lurking. Oh, thank you, you guys. Thank you for smashing that like. I appreciate it so much. It's free to do. Thank you, Bradley, for the PayPal donation. Just seen that come through too. Thank you so much. It helps me to keep doing these things for you and bringing you guys this information. So thank you so much for your PayPal donation. I appreciate it. Kate says I take Willow shopping with me. Okay, so similarly, in Hazen versus State, the court reversed a death sentence imposed against Mr. Hazen, one of 3 co-defendants involved in a burglary, an R, and a M. I let it slip sometimes, you guys. As long as it's not consistent, they don't jump on you for it. But if you're consistently saying it, they do. So when I do catch myself, I try not to say those words. 3 men entered the house of a couple, shot a man at point blank range, taking his life, and took turns doing you know what to his wife. One of the non-trigger men co-defendants received a sentence of life imprisonment in exchange for testifying against the other 2. Mr. Hazen, the other non-trigger man, was sentenced to death at trial. In reversing the sentence, the court found it was disappropriate to sentence Mr. Hazen to death, given that he was less culpable than the non-trigger man co-defendant who had cut a deal and testified against him. The state asserted that it wished to sentence all 3 co-defendants to death, but made a strategic decision to offer one of the non-trigger men a deal in order to strengthen their case against the other 2. The court concluded this was not an adequate justification to depart from the principle that justice requires equality before the law. Now, this is the one that I am saying is going to probably have the death penalty taken off the table for Chad. The court then reaffirmed that a life sentence for one defendant precludes a death sentence for a less culpable co-defendant. The state overturned on other grounds the defendant was sentenced to death for the armed robbery and felony murder of a liquor store clerk. His co-defendant, the trigger man, received a life sentence. In finding that there was no evidence Hall was the prime mover in the crime, Hall's death sentence was vacated. So we see it over and over and over and over, you guys. Under these circumstances, the death sentence imposed upon Hall for the same crime in which the co-defendant Triggerman received a life sentence is disappropriate. Other cases have iterated the same principle, reducing death sentence to life with possibility of parole after 25 years, where co-defendant was the actual killer and was sentenced to life through the defendant's sentence to death, had also shot the victim. In Reddix versus the state, finding the death sentence disproportionate for less culpable defendant involved in planning and executing the robbery that resulted in death, where co-defendant received a life sentence. Bullock versus the state, finding death sentence disappropriate for the defendant who held the victim down while co-defendant delivered fatal blows, and co-defendant received a life sentence. In this case, the state has made clear that Ms. Vallow is more culpable than Mr. Daybell. Vera, at this point, that's not really what they are honing in on. What they're honing in on is in Lori's trial, they said that without her manipulating Chad and Alex, without her pushing for this to happen, these murders would never have happened. So they are saying that she was the head honcho. She's the one that, got this plan together. She's the one that made sure it was carried out. She manipulated them into doing what she wanted them to do. They said that in her trial, that if Lori had not have done, like, they only did what Lori told them to do. So because they said that in her trial, they've really shot themselves in the foot for Chad's trial to find that he is more culpable than her. Okay? And it's sad because I believe they both should have got the death penalty. See, in this case, the state made it clear that Ms. Vallow was more culpable than Mr. Daybell, whom she emotionally and Xually manipulated into following her. As the state repeatedly asserted in her trial, the conspiracy was driven by Lori's desire for and use of money, power, and sex, and was indeed set in motion by Lori. Right here in the transcript, this is the transcript, page 3830, lines 13 to 15, they state that this conspiracy was asserted and driven by Lori's desires for the use of money, power, and sex, and was indeed set in motion by Lori. They said that in her trial. They put it all on Lori, as if saying if Lori hadn't have set this in motion and was driven for money and everything else and didn't manipulate them, it wouldn't have happened. And they were saying this to get a conviction on her. But they shot themselves in the foot when it comes to Chad. What are they going to do now? Go back and say, well, Chad's the one that set this all in motion. You know what I mean? Yes. Did he do if this is what happened, and if Lori was the mastermind and they were manipulated and whatever, are they still at fault? Absolutely. It does take two, Stormy. It does take two. But when you go for culpability, who was the mastermind and everything else, they're putting it on Lori in her trial. They can't turn around now and play the same theme for Chad, because the defense will be all over it. Whoa, wait a minute. In Lori's trial, you said she was the mastermind. Now you're trying to say Chad is the mastermind. You know what I mean? They've kind of shot themselves in the foot. And I think this is what is going to get that death penalty removed. So don't be surprised, you guys, when the judge has no other option but to take the death penalty off the table for Chad. Just my opinion. Just my opinion, you guys. That right, Burgess Taylor, yes, they do have a choice. But what I'm saying is, when in Lori's trial, when they solidified Lori was the aggressor, Lori's the one that came up with the plan, Lori was the mastermind, Lori set this in motion, and it was driven by Lori's desire for use of money, power, and sex. When you drive that into your case, it's like, okay, well, Alex and Chad, and I'm not saying what they did is any less vile and wrong than what Lori did, but they're saying that Lori, without Lori masterminding all this and manipulating it all, it never would have happened. I'm not taking away from what they did was wrong and they should be punished. And I think they both should have the death penalty. But the prosecution messed up when they kept trying to keep these cases together instead of giving her speedy trial. Okay, so, and when they say this, and they've got the transcripts where the prosecution is saying that Lori was the mastermind, they're going to have a problem in Chad's case, and John Pryor is going to be all over this. The state has consistently argued that Lori manipulated both Alex and Mr. Daybell into being her followers. See this where they say it in the transcript on this page and these lines. Lori manipulated Alex through religion. She manipulated Chad through emotional and sexual control. They said this. The prosecution said this in Lori's trial, and they've got it. This is on page 3859, line 25, where they say this in the trial of Lori. She groomed Alex. They say this in the transcript. Lori uses sex to manipulate Chad, and Chad seeks confirmation from Lori repeatedly. The state has presented evidence and argued that Lori was the leader of the alleged conspiracy, and Chad only followed Lori's direction. They said this. I'm not saying that Chad should be off the hook. But if they're saying that this is all on Lori, and if it hadn't been for Lori, Chad never would have done this, Chad still has to be held responsible, right? Chad is not going to act with without Lori saying so. Okay, they say that in the transcript. What does Chad say? Just grab me by the storm and I will follow you to the ends of the universe. Not, will you follow me, Lori? He says, I will follow you. So there's text that they went over where he says this. Yet despite the core of the state's case against Ms. Vallow centering around her heightening culpability, her manipulation of Mr. Daybell, and her directing of the alleged conspiracy, only Mr. Daybell faces the death penalty. They both were facing the death penalty, but prosecution messed up. Well, the state's prosecution of Ms. Vallow has established that even if all the state's allegations were accepted as true, Mr. Daybell was not more culpable in the alleged conspiracy than Mrs. Vallow. He is the co-defendant facing the most extreme punishment available. Well, he is now. They were both facing the death penalty. And the state themselves drove home to the jury that basically Chad was less culpable than Lori. They did that. They told the jury that Lori was the most culpable. Not Chad, not Alex, Lori. So what John Pryor is saying here is absolutely true. And he's got the transcript of the trial in front of him stating which page they said that on, which line they said that on. Well, the state's, okay, hang on. Okay, so the state made the allegations in her trial. We have no choice but to believe it because the prosecution said it in Lori's trial. So even if all the state's allegations were accepted as true, Mr. Daybell was not more culpable in the alleged conspiracy than Ms. Vallow. He is the co-defendant facing the most extreme punishment. So usually, if somebody is more culpable than the other, they get a more harsher sentence. And because Lori didn't get the death penalty, they are saying that Chad shouldn't either. And I agree. As much as I don't want to, I agree. You can't say that this was all Lori. Lori masterminded this. Lori pushed it. Lori manipulated. Lori, and not get her the death penalty, but then expect, as they said, Chad and Alex followed what she wanted them to do. They're followers. They're not the ones that masterminded it all. They're carrying out orders. You know what I mean, you guys? You can't give him a worse sentence than what you've given her if you're saying that she is more culpable. And they have said that she is more culpable. As much as I don't like it, the prosecution said she was the head honcho. If it wasn't for her, it wouldn't have happened. They said it. They shot themselves in the foot. The state seeking of Mr. Daybell's death is cruel and unusual. Additionally, as other cases have pointed it is arbitrary and capricious in violation of Mr. Daybell's due process rights to continue seeking the death penalty against him when a more culpable co-defendant has been spared that outcome. 100%. And we've got nobody to blame here but the prosecution. So in the United States versus literal, multiple members of the Aryan Brotherhood were put on trial for a series of murders committed at the behest of the organization. So when two of the leaders of the organization were not sentenced to death, the government withdrew its intention to seek the death penalty against the 7 less culpable defendants. So if you can't get the 2 that were the head honchos for death penalty, then anybody that was less culpable than them can't get the death penalty either. However, the government continued to seek the death penalty against Gary Joe Luttrell, an individual that was incarcerated for violent offenses and who strangled another incarcerated individual to death at the behest of the leaders of the Aryan Brotherhood. In support of the decision, so this is almost the same. He strangled this other incarcerated individual because the leader of the Aryan Brotherhood told him to do it. So we're talking about Chad and Lori here. We got to put them in those positions. If they're saying Lori was the head honcho, the leader of the Aryan Brotherhood is the head honcho here. If they're saying that she was more culpable than who actually carried it out, that would be Gary Joe Luttrell. Gary is Chad. So the Aryan Brotherhood leader is telling Gary, this is what you need to do. This is what we got to do. And Gary does it. So it's the same basic concept of Lori and Chad, where the prosecution is saying that Lori was more culpable. She was the head honcho. They did that to themselves. Instead of saying they were equally in charge, they drove it home with the jury in that trial that Lori was the head honcho. She was the one that put this all together and had them carry it out. In support of the decision to continue seeking his death penalty, the government presented evidence that Mr. Luttrell committed a brutal crime and was himself a dangerous criminal with a violent history of violence. The district court noted that the government had already tried the leaders of the conspiracy, and it is clear that the government considered the 2 defendants not sentenced to death to be the 2 most culpable. Those are the leaders. The leaders were the most culpable, and they weren't sentenced to death. Lori, they're saying, is the most culpable. She wasn't sentenced to death. But they're trying to sentence this Gary, who was less culpable, to death. To be the most culpable lawyers in the entire organization. The district court explained that it was at a complete loss to understand how the government can, in good faith, seek death against a lower level member of the Aryan Brotherhood like Mr. Luttrell when it does not seek that ultimate punishment against the more culpable commissioner leaders. The government countered that Mr. Luttrell was the most culpable person regarding the individual murder that he committed, even if not the most culpable as to the entire conspiracy. But that was rejected by the district court since the government had made the decision to change this murder as part of a conspiracy. And that's exactly what they did with Lori. They put it all on her. So you can't put it all on one person and give them a lesser sentence than ones that you are saying are less culpable. It would be flatly inconsistent with the charges brought in the indictment to find that the government need not consider the relative culpability of Mr. Luttrell in comparison to that of the members of the organization charged in the indictment and in comparison to the conduct committed by the organization as a whole. In light of these facts, no rational decision maker could conclude that Gary Luttrell's conduct was so reprehensible and his moral culpability so great that he should face execution when the leaders of the organization, the men who ordered Mr. Luttrell to kill, and several men who have committed identical crimes to Mr. Luttrell, and furthermore of the Arab Brotherhood, don't face similar punishment. As such, the district court found that it violated due process as arbitrary and, here we go again, capricious to seek the death penalty against Mr. Luttrell when other members of their organization did not face that possibility. The court then struck the death penalty as a sentencing option. So the conclusion. For the foregoing reasons, any death sentence imposed upon Daybell would violate the fundamental constitutional principles requiring equal justice under the law and would be unconstitutionally disappropriate, excessive, fundamentally unfair, and arbitrary and capricious. Okay, so in the State versus Page, engaging in ultra case oh my God, I can't speak now. Review in death penalty case and noting that the Supreme Court's opinions in Edmund and Tyson require this court to focus upon the relative culpability of each co-defendant in the commission of the capital offense. In the State versus Cawthorn, engaging in intra-case proportionality review and noting that disparity in sentencing may only exist if there is rational basis for the decision of the jury to impose the death penalty on one perpetrator and not another. Mr. Daybell respectfully requests that this court strike the state's August 5th, 2021 notice of intent to seek the death penalty pursuant to the 6th, 8th, 14th Amendments to the United States Constitution. So that's that. Now they got another motion here. Motion to strike the death penalty as arbitrary, capricious, and disproportionate in light of striking death in the co-defendant case. So they're going to go over this now. So do you guys get what I'm saying here with what's going on? This may just be another, when was this filed? This was filed yesterday also. So it comes now the defendant, Chad Daybell, and through the undersigned counsel submits this motion to strike the death penalty as arbitrary, conspicuous, disproportionate in light of striking death in the co-defendant's case pursuant to the 6th, blah, 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 amendments. As cited below, Mr. Daybell respectfully requests that the court strike the death penalty as a sentencing option to avoid a situation where the severity of punishment turns on a co-defendant's decision whether or not to waive speedy trial rights, as opposed to the relative levels of culpability in violation of fundamental constitutional rights and judicial fairness. Factual background. Here we go again, you guys. The state of Idaho has charged Chad Daybell and Lori as co-defendants in connection with the deaths of Tylee, JJ, and Tamara on August 5th, 2021 and May 2nd, 2022. The state filed its notice of intent to seek the death penalty against Mr. Daybell and Mrs. Vallow, respectively. On August 19th, Mr. Daybell waived his right to a speedy trial. On March 3rd, the court severed Mr. Daybell and Ms. Vallow's trials. On March 21st, 2023, the court struck the state's May 2nd, 2022 notice of intent to seek death penalty against Ms. Vallow. From the bench, the court stated that striking death was an appropriate discovery sanction and was necessary to ensure that the constitutional rights of Ms. Vallow were protected. So the constitutional rights were her right to a speedy trial. The court did not extend the decision to Mr. Daybell, even though the state had committed the same discovery violations against Mr. Daybell, since he had waived his right to speedy trial. As such, the court has permitted the continued pursuit of only one co-defendant's death due solely to the defendant's waiver of a speedy trial rights. So, because he didn't waive his right to a speedy trial, they're saying that that's why they're not taking the death penalty off when they should, but I don't know. The fundamental respect for humanity underlying the Eighth Amendment's prohibition against cruel and unusual punishment gives rise to a special need for reliability in the determination that death is the appropriate punishment in any capital case. So they're going to cite more cases here. The U.S. Supreme Court has held that the Eighth Amendment demands that the death penalty as the most severe punishment must be limited to those offenders who commit a narrow category of the most serious crimes and whose extreme culpability makes them the most deserving. See, this is where they are holding on to this extreme culpability. Because, like I said before, they have said that it's Lori Vallow that was most culpable. So they're just citing more cases here, like they did in the other motions that we just heard. There must be meaningful basis for distinguishing the few cases in which the death penalty is imposed from the many cases in which it's not. Amongst the entire class of murders, the death penalty must be reserved for the worst of the worst. In Kansas versus Marsh, while every murder is appalling, the average murderer is insufficiently culpable to justify the most extreme sanction available to the state. In Akins versus Virginia, though the state has a wide latitude under the Eighth Amendment to seek severe non-death sentences in all other criminal cases, the Eighth Amendment special constraints on the death penalty must be enforced by this court. In this case, there is a single distinguishing feature that explains why the state continues to seek the death penalty against Mr. Daybell, even after it was struck against Ms. Vallow. Mr. Daybell waived his right to a speedy trial. Willingness to waive speedy trial rights cannot constitutionally be the deciding factor in who lives and who dies. In the People versus Kilner, holding that in capital cases, similarly situated co-defendants should not be given arbitrarily or unreasonably disparate sentences. When a co-defendant or co-conspirator is equally as culpable or more culpable than the defendant, disparate treatment of the co-defendant may render the defendant's punishment disappropriate. The willingness to waive speedy trial rights does not correspond to the defendant's most culpable and deserving of death, and therefore it is unconstitutionally arbitrary under Furman and Gregg for this willingness to waive to determine which co-defendant remains eligible for the death penalty. The prosecution cannot continue to seek Mr. Daybell's execution solely because he waived his speedy trial rights, while his co-defendant did not. It would be at odds with the reality of the criminal justice system and would establish dangerous precedent regarding how to advise clients in co-defendant cases to suggest that Mr. Daybell should face a more severe punishment than his co-defendant simply because he waived his constitutional right. It's unconstitutionally arbitrary and conspicuous to continue seeking Mr. Daybell's death. Given that the death penalty must be reserved for the worst of the worst, the pursuit of a death sentence must be based on the relative culpability of a person accused of murder and cannot be based on arbitrary or conspicuous factors outside of the defendant's own alleged offenses and characteristics. See Chapman versus the United States. Nana says, Willow, should Pryor have filed on this issue when the judge dropped the DP against Lori, even though he waived his speedy trial? He could have, but I think they wanted to wait until they seen what happened in Lori's trial. And as we can see here, they are using what the prosecution said in Lori's trial to fight this here for Chad, that the death penalty in his case would be unconstitutional because they drove home that Lori was more culpable in all of this than Chad. And because the prosecution pushed that and said that she was the most culpable to get a conviction in her trial, they're saying that Chad was less culpable. So they can't give him a worse sentence than what they gave somebody who was more culpable. That's why I said they shot themselves in the foot. I think they have a good argument here. I wish they would both get the death penalty. Don't get me wrong. I think they are both equally responsible for each and every one of those deaths. But the prosecution messed up. The government violates a defendant's right to due process under the Fifth Amendment to the United States Constitution when its decision to seek the death penalty is arbitrary and conspicuous. Striking the death as a potential sentencing option after finding that the government's decision to seek the death penalty was arbitrary when compared to co-defendants. Ultimately, to comport with a criminal defendant's due process rights and to avoid violating the right to be free from cruel and unusual punishment, the death penalty may only be sought in a way that can rationally distinguish between those individuals for whom death is an appropriate sanction and for those whom it is not. The legitimacy of our entire system of capital punishment is premised on the notion that the death penalty must be imposed fairly and with reasonable consistency or not at all. In Greg 428 U.S., Furman mandates that where discretion is afforded a sentencing body on a matter so grave as the determination of whether a human life should be taken or spared, that discretion must be suitably directed and limited so as to minimize the risk of wholly arbitrary and conspicuous actions. Indeed, the death sentences examined by the court in Furman were cruel and unusual in the same way that being struck by lightning is cruel and unusual. 4. All of the people convicted of capital crimes, many just as reprehensible as these, the petitioners in Furman were among the conspicuously selected random handful upon whom the sentence of death has in fact been imposed. The 8th and 14th Amendments cannot tolerate the infliction of a sentence of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed. So in the Gregg case, internal quotations and citations have been omitted. Just as the decision of who lives and who dies cannot rest on chance, it also cannot turn on the rights asserted or waived by a criminal defendant during prosecution. In the United States versus Jackson, the Supreme Court examined and struck down the Federal Kidnapping Act, which prohibited the death penalty for defendants who assented to the bench trial and abandoned their right to contest their guilt before a jury, but authorized death where a defendant proceeded to jury trial. The court reasoned that the goal of limiting the death penalty to cases which a jury recommends in its entirely legitimate one, but that goal can be achieved without penalizing those defendants who plead not guilty and demand a jury trial. In a similar way, it was the legitimate aim of this court to ensure that Ms. Vallow did not face the death penalty based on incomplete or late discovery, but that the goal does not permit authorizing differential punishments between her and her co-defendant against the stated desires of the prosecution solely because she asserted her right to a speedy trial where her co-defendant waived it. The sole distinguishing feature between the penalty being sought in this case and Mr. Daybell's co-defendant case is that Mr. Daybell waived his speedy trial rights, not because Mr. Daybell is more culpable or somehow deemed more deserving of the death penalty. Only because Mr. Daybell waived his speedy trial rights and thus permitted the state greater time to comply with its discovery obligations does he continue to face the death penalty, while Ms. Vallow does not. Thus, the difference in sentencing being sought between these two co-defendants is not due to the perceived or argued for culpability in relation to the alleged offenses, but rather due to the state's discovery violations and Mr. Daybell's willingness to permit more time. So they're saying that the only reason they took the death penalty off the table for her was because they were violating her speedy trial rights. And just because Chad waived his right to a speedy trial, he should be entitled the same thing, since now they have said that she was more culpable than he was. This is just two reasons why they're saying that they should be removing the death penalty from his case. Permitting more severe punishment because the defendant waived his speedy trial rights raised additional constitutional concerns. If Mr. Daybell had not waived his speedy trial rights, he would not be facing the death penalty. He was not advised of this potential outcome at the time of his waiver, and this raises many issues. Both the Sixth Amendment to the United States Constitution Article 113 of the Idaho Constitution guaranteed to criminal defendants the right to a speedy trial. State versus Prano. The speedy trial guarantees are designed to minimize the possibility of lengthy incarceration prior to trial, to reduce the lesser but nevertheless substantial impairment of liberty imposed on an accused while released on bail, and to shorten the disruption of life caused by arrest and the presence of unresolved criminal charges. While defendants have constitutional speedy trial rights, these constitutional rights can be waived. A waiver is a voluntary relinquishment of or abandonment of a known right or privilege, and the court should indulge every reasonable presumption against waiver. When Mr. Daybell waived his right to a speedy trial on August 19, 2021, he did not know that it may lead to a situation where he would, solely on the basis of this asserted right, face far more severe punishment than his co-defendant. As such, if this court does not strike the death in this case to ensure reasonable equal treatment of the co-defendants under the law, then Mr. Daybell's initial waiver will be called into question, since he was not advised of this potential and significant consequence. Even if an appellate court determined that his initial waiver was made knowingly, he would have a strong argument that he was provided ineffective assistance of counsel under the Sixth Amendment in Article 1, Section 13 of the Idaho Constitution, since he was never advised of this possibility. So they're throwing it on the table right now that if he's found guilty and he's facing the death penalty, he was never advised that this could happen by waiving his rights to a speedy trial. So he's going to, he would have a strong argument that he was provided ineffective assistance of counsel. So they're putting it out there already that that's what they intend to do if he's found guilty and if the death penalty stays on the table. For the foregoing reasons, Mr. Daybell respectfully requests that this court strike the state's August 5th, 2021 notice of intent to seek the death penalty pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution, Idaho Constitution, Article 1, Section 6, 7, 8, and 13. In doing so, the court will ensure that decisions of whether the defendant should live or die do not turn on whether they have raised or asserted speedy trial rights, but rather are rooted only in relative levels of culpability and personal characteristics. So notice is hereby giving that on the 29th day of November, 2023 at the hour of 9 a.m. or as soon thereafter as counsel be heard, John Pryor, attorney for the defendant, in the above name will call up for hearing a defendant's motion to strike the death penalty as arbitrary, conspicuous, and disappropriate before Honorable Judge Stephen Boyce. So we already knew that there was motions that were going to be heard on November 29th. He is just giving them notice here that he is also going to be bringing up this motion on the 29th also. And that's that. So that's the two things that were filed, you guys. Recently, I believe, let me hear what you guys think. What do you guys think? Do you think that the death penalty should be removed for Chad Daybell also? What do you guys think? What are you guys thinking? I see in the comments what you guys are thinking about it. So now knowing what the laws are, and, you know, if there's more than one person that has committed the crime, co-defendants, if one is more culpable than the other, and from what I just read, the prosecution is saying that Lori was more culpable, you can't give somebody who was less culpable a harsher sentence than what you gave the one who was more culpable. I don't think it should, but the law is the law. Yeah. Me too, Nana. I was thinking the same thing. The judge is really stuck here. Should he be getting the death penalty? Yes. Is he going to get it? I think the judge is going to have to remove the death penalty. Why? Because the prosecution drove home in Lori's trial that she was the one that was more culpable. So if she was the one that spearheaded this, that brought this all to fruition, that manipulated, like they said, the prosecution said this, you guys. They basically said she was more culpable than Chad, right? They said that. And she didn't get the death penalty. Now, is there going to be some arguments on this? Probably. Are they going to be enough? I don't think so. And that's just my opinion. Like I said, I worked in the legal criminal law for over 30 years, worked in the legal field. Now, I do know that US law is a lot different than Canadian law, but there's some that are a lot of the same. And I'm feeling that this judge is stuck now between a rock and a hard place. And I don't think he's going to give an answer right away. I think he's going to take it under advisement. I don't know. Me personally, I think the prosecution messed up. And I think they're going to pay for that by the death penalty being removed. My thoughts. Nana says that Willow should prior have filed on this issue when the judge dropped the DP. I think I answered that. I think John Pryor was waiting for Lori's trial to conclude so he could go over all of this and make his best argument to have Chad's dropped. And I think because he didn't fight it right away, gave him the opportunity to gain more insight as to what happened throughout Lori's trial, and culpability is being one of them. The prosecution saying that it was Lori that came up with this plan, put this plan together, manipulated, and had it carried out. They're saying she is the head honcho. Now, we've seen with when we went through the cited cases with the Aryan Brotherhood, that the two head honchos of the Aryan Brotherhood said to these other guys, hey, look at this is what we need to do. I need you, and you to do this. That they didn't get the death penalty. They got life in prison, but they were going after the death penalty for whoever carried it out, which in that case too, the two leaders of this who devised the plans and everything else were more culpable and ordered the others to do it. You know what I mean? So, I mean, it's a catch-22. I don't know. I don't know what the prosecution is going to come back with. I guarantee you they're going to come back and fight it. They're going to come back with probably other cases. They're going to dig up other cases that they can cite where they can say, look at this one was the mastermind and everything, but this one is held more culpable, even though we said that in that trial. You know, did we lie? I don't know what they're going to say. I really don't. Well, we don't know if Chad did the actual or just helped bury the bodies, gave the place to bury them and everything they needed to bury them. We still don't know who actually took the lies. We know Chad did with Tammy because he was the only one that had the ability to do that, because it happened at night while they were in bed. But as far as JJ and Tylee, we still don't know which one did the deed, right? We still don't know. And with Alex being dead already, I think Chad is going to say he's the one that did it. All I did was provide the land, the shovels, and everything else, the tools, for him to do it. And let him bury them on my land. He could very well say that. Right? That would make him less culpable than Alex. Because Alex is the one that actually did the deed. So I think there's still a lot more here that is going to be thrown. John Pryor is not a stupid man. I can guarantee you that. And he's bringing up the culpability. And if when the prosecution in the first trial of Lori throws everything at Lori, she's the one that was culpable. She's the one that put this all together. She's the one that manipulated. She's the one that is the one that was going to gain the most by all this. They did that, right? Okay, well, if she's the one that's more culpable, then you can't give Chad a worse sentence than what she got. That's going to be hard to overcome. Can they? I don't know. Yeah, Chad did still take out his wife. Yes. So could they use that, Nana? That's a good point. Could they use that as a contributing factor, right? Okay. But Lori was also charged in the conspiracy to have Tammy taken out also, right? Yes, he's still an accomplice. Yes. Guilty by association. Exactly. The same as if, you're with somebody who robs a store and somebody dies in that robbery, you're as much to blame as the other, right? But when we're going as far as the death penalty, there's a lot, it's a lot stricter as to who can get the death penalty. And if you're saying that they both did the acts, they were both putting this together, and you give one a life sentence, you can't give the other the death penalty. Right? And even though we know Chad took his wife's life because there was nobody else that could have done it. Alex wasn't in his bed with his wife. Lori wasn't in the bedroom with his wife. The only one that was in the bedroom was Chad. Right? So, yes, he's fully responsible for that. Can they use that one and say, well, we're going for the death penalty on that one for the death of his wife? I don't know. I don't know what they're. Guarantee you the prosecution is going to come back with something, you guys. They're going to come back with something. I just hope that it's a good argument that they come back with. Let me get this off the screen. Okay. So that's what I got for you guys today. We're going to have to wait and see what the prosecution comes back with. And how are they going to fight this, right? How are they going to respond? How are they going to neutralize what they did in Lori's trial? We're going to have to wait and see. This trial is scheduled to go ahead April 1st, 2024. Chad is back in court on the 29th. I have a funny feeling, you guys, that the prosecution may bring this forth sooner. So they have motions hearings already scheduled for November 29th. But with the defense now filing this, I don't know if they are going to want to deal with this before they deal with the issues on the 29th. They may want to separate the two. So we'll have to wait and see what, sorry, you guys, what the prosecution comes back with. So with that being said, you guys, I'm going to wrap it up. Thank you, mods, for being here and taking care of the chat while I was reading through the documents. It's a wait and see right now, you guys. We'll see what the prosecution comes up with, and hopefully they have a good argument as to why the death penalty should stand. I believe they both deserve it, and I hope she gets the death penalty because she's still got to face Charles Vallow with his death, and she could be getting the death penalty there. So love you too, sister. Thank you for being here. All my mods, thank you. I appreciate you. For those who did send the PayPals, thank you so much. I appreciate it. It helps me continue to bring this stuff to you guys. It is very much appreciated. So with that being said, you guys, I'm going to wrap it up and I'm going to end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now.